Thank you, Ada. I hope people can hear me in the back. I'm sort of used at Columbia to speaking in fairly large rooms, so I think my voice will carry up to the back. I'm very happy to be here in Perpignan, and thank you for inviting me and organizing this wonderful conference. So I will speak for what professors, since we don't know how to count really, we think an hour is 45 minutes, right? So I will speak for the hour of 45 minutes, and then I hope before lunch we can have a few questions. Please feel free to ask some questions once I am finished. I am going to speak today about an issue which is deeply rooted in American history, but is very much a political question today in the United States, and that really is, who is a citizen of the United States? Or more particularly, the question of birthright citizenship. Birthright citizenship. That is the principle that anybody born in the United States is automatically a citizen when they are born. Doesn't matter who their parents are, doesn't matter what their religion, their race, whatever, automatically a citizen at birth. Now, this relates actually to an idea that I generally disdain, but in this case actually is valid, and that is American exceptionalism. Because birthright citizenship today is exceptional in the United States. I am not going to comment on the law of France, which I do not even understand, but I believe it is the case that no nation in Europe anymore recognizes automatic birthright citizenship. The last country to abolish it actually was Ireland in 2008. That doesn't mean people cannot become citizens, but they have to go through some process if their parents are not citizens. Whereas in the United States, it doesn't matter who your parents are. This principle was adopted as part of the effort to purge the United States of the legacy of slavery. And it remains an eloquent statement about the nature of our society. In a world where most countries limit access to citizenship via ethnicity or culture or religion or the origin of the parents, it does set the United States apart. I really don't know how many other countries in the world now operate on this principle, but there are not very many. Oddly, those most insistent today on American exceptionalism are the ones trying to get rid of this one legitimate area of American exceptionalism, birthright citizenship. Because as I say, the debate over who should be an American is as old as the country, but as recent as yesterday's newspaper. Again, as in France and many other countries, the question of immigration has become a very, volatile political issue in the United States, particularly what are called illegal immigrants, undocumented immigrants. There may be 10, 11, 12 million illegal immigrants in the United States. Most of them, it seems, from Mexico, Central America, some parts of Latin America. They are not citizens, they are not legally in the United States, but according to the Constitution, the 14th Amendment, if an illegal immigrant has a child in the United States, the child is an American citizen, regardless of the status of the parents. Now, as I say, this has become, conservatives particularly have been agitating to change this. The state of Arizona, which is one of the most peculiar states in the United States lately, they have tried to pass laws saying we will not recognize the children of illegal immigrants as citizens until somebody pointed out that a state cannot just abrogate the Constitution of the United States. Governor Romney, the probable Republican candidate for president this year, has said that his aim is to get rid of all these illegal immigrants and their children through what he calls self-deportation. Self-deportation. He uses that term. In other words, it's voluntary. That is to say, the principle is if you make life so miserable for these people, they will voluntarily leave the country. Not that the Obama administration is much better. The Obama administration has been deporting many thousands of people who are illegally in the United States, far more than the Bush administration did. And the result of that is actually thousands of children who are American citizens have been left in what we call foster care, have been placed with other families because their parents were sent out of the United States. They could not be deported because they are citizens of the United States, but their parents are thrown in. So a country which supposedly respects the validity of, the stability of the family is separating families because of the different status of the parents and the children. But in all this political debate, I'm sorry to say, there is very little historical understanding. No politician that I have heard actually understands where this principle of birthright citizenship came from, why it is in the laws and the Constitution. My point really is that to understand it, one has to go back to the era of the Civil War and Reconstruction, about which, as Ada said, I have written a great deal during my career. The process of the principle of birthright citizenship was part of the process of coming to terms with the legacy of the Civil War, that is, the destruction of slavery and the preservation of the American Union. In some ways, one might almost say we are still trying to work out the consequences of the end of slavery in the United States. And the debate over birthright citizenship is part of that long historical struggle. Now, even though, as I said, I have written a great deal about Reconstruction, I must admit that most Americans know almost nothing about that period. I find this disheartening since I've written very long books about it. But the fact is that even if we are not aware of it, Reconstruction, the period after the American Civil War, is part of our lives in the United States today. Many of the questions facing the United States right now, political questions, social questions, are Reconstruction questions. What are the relative powers of the federal government and the state governments? How to respond to terrorism, because, among other things, Reconstruction was a moment of homegrown terrorism in the United States, the famous Ku Klux Klan and other organizations. It's a sad fact, but it is true that the Ku Klux Klan and other similar groups in Reconstruction killed more Americans than Osama bin Laden did as part of their terrorist campaign against the former slaves and the governments that they were taking part in. And Reconstruction was a remarkable moment in American history. Let me just give you one example of that. I think everybody in the world knows that Barack Obama is the first African-American president of the United States. If you know anything about Obama, you know that. 1 out of 44. We've had 44 presidents, more or less, because there's debate of whether you count Grover Cleveland once or twice, but assuming that Grover Cleveland was only one person, 44 presidents, 1 black. That's a comment on American history, but here's a lesser-known comment. Since the Constitution was ratified, well over 1,000 people, well over 1,000 have served in the United States Senate. I don't know how many, but quite a few. Of those 1,000, 1,500, whatever it is, only 6 have been black. 6 out of 1,000 is a much worse percentage than 1 out of 44. Today, in the year 2012, there is no black person in the United States Senate. The Senate is completely white, except for 1 Hispanic, and I don't even know if there's an Asian or not in there. But 2 Hispanics, actually, Martinez and Rubio. But no black person in the United States Senate. But of those 6, in all of American history, 2 were elected during Reconstruction. 2 men, black men from Mississippi, were elected to the Senate. So that shows you what a remarkable moment that was, considering the long sweep of American history. Well, I guess I shouldn't say long compared to the sweep of French history, but it's long from our point of view. So the question central to this conference, in a way, of heritage, identity, are in some ways Reconstruction questions. Although their origins go back as far as the nation itself to the American Revolution. What is a nation? You all know, of course, the famous statement of Benedict Anderson that a nation is an imagined political community. A nation is not just a physical space on the map, but an imagined community. Its borders are intellectual as well as geographic. What are the borders of the intellectual borders of the American nation? Well, many scholars, political scientists particularly, who like to build models of things, have distinguished between two kinds of nationality, or two kinds of nationalism. One is what they call civic nationalism, which envisions the nation as a community based on shared values, shared political institutions, with membership open to many different kinds of people who share those values. The other is what they call ethnic nationalism. That is to say, a nation is a community of descent with a particular ethnic or linguistic heritage. France is actually often cited as a good example of the civic nationalism, Germany of the ethnic nationalism. If you are part of the German folk, a certain concept of the people, you are automatically German even if you and your ancestors for centuries have lived somewhere else. You're still, by descent, part of the German nation. Whereas in France, many people can become French regardless of their heritage, as long as they sort of accept the principles of the French nation. Now, Americans have tended to identify ourselves with this civic model. In other words, the raison d'etre of America, of the United States, rests on principles. The Declaration of Independence, liberty, equality, democracy. But in fact, and really the point is that for many, many years, American nationality was a combination of civic and ethnic nationalism. Both of them go back to the era of the Revolution, when a nation was created committed to the principle of liberty, yet resting to a considerable extent on slavery. Slave owners controlled the federal government for most of the period before the Civil War, and the power of slavery shaped these questions of identity, of heritage, and of nationality. Slavery gave American nationhood a powerful exclusionary dimension. It created a boundary of citizenship which rendered blacks, whether free or slave, invisible, so to speak, to those creating or imagining. When they imagined the American community, they did not imagine black people as part of it. One of the great myth makers of that era, I'm sure you're all familiar with, a Frenchman, although he became an American, Hector St. John Crèvecoeur, wrote, famously, "What then is the American, the new man?" And he answered, "He is a mixture of English, Scotch, Irish, French, Dutch, German, and Swede. He is either a European or the descendant of a European." Now, when Crèvecoeur was writing, 1/5 of the population were people of African descent, the highest proportion in all of American history, and yet he ignored them. He didn't mention them at all. They're not American in Crèvecoeur's vision of the new man that represents the United States. So who was a citizen before the Civil War? Well, the answer to that is nobody really knows. The Constitution mentions citizens. It talks about the privileges and immunities of citizens, but it doesn't tell you who these citizens are or what their privileges and immunities might be. But increasingly, citizenship became defined as something limited to white people. Only whites could be citizens. In fact, one of the first laws passed by Congress under the Constitution in 1790, the first law regulating immigration and naturalization, laid out that anybody in the world, at least this is how you will read about it in many books, anybody in the world could immigrate to the United States and after 5 years become a naturalized citizen. After all, the United States, as Tom Paine said, was an asylum for mankind. That was the purpose of the revolution. People seeking liberty in other countries could come to the United States. But did I say everybody? Actually, that's not quite right, because there's one little word in that law, white. Any white person can emigrate to the United States and become a citizen. The word white, therefore, actually excludes the large majority of mankind from access to citizenship by immigration. Even though, if you read textbooks, you'll say this is the period of open immigration. It really isn't that open if only white people can take advantage of it. And that restriction lasted a long time. It was not until 1870 that black people, people of African origin, could become naturalized citizens. It was not until the 1940s that Asians could become naturalized citizens. So that racial definition of citizenship lasts well into the 20th century. And it shows you, as I say, the power of that boundary. And in fact, as the 19th century went on, the rights of even free black people in the United States became narrower and narrower. In fact, in a country that lacked, the United States lacked the traditional bases of nationality. In other words, we didn't have long-established physical boundaries. The physical identity of the United States kept changing every 20 years in the 19th century. We did not have a powerful and menacing neighbor that helped to create a sense of identity. We didn't have a historic religious or ethnic unity. The definition of the nation came to be the political institutions themselves, the democratic institutions. The right to vote became the emblem of citizenship. Not in law, because women, for example, were citizens, no question, free women, and yet they could not vote, but in this imagined community. In fact, the American Dictionary of Noah Webster, his famous American dictionary published in the 1820s, under the word, if you look up the word citizen, it says somebody who is a member of a political entity or something like that, but then it says in the United States, someone with the right to vote. Not in England, not in France, not in Germany, not in other places, but in the United States, the right to vote became intimately related to the notion of citizenship. Now, the problem with that is black people could not vote. Even free black people in most states in the North could not vote before the 19th century. So they are kind of, again, excluded from this definition. And this language of racial exclusion was common in the political dialogue. Stephen A. Douglas, probably the most important political figure of the decade before the Civil War, and the man, of course, who debated with Lincoln in the famous Lincoln-Douglas debates of 1858. Today, we remember the Lincoln-Douglas debates. We remember Douglas as the man who debated Lincoln. But in fact, Lincoln became famous because he's the man who debated Douglas. Douglas was far more important than Lincoln in 1858. Lincoln rose in prestige because he was able to debate Stephen A. Douglas. But in these debates, Douglas made very clear, he said, I believe this government was made on the white basis. It was made by white men for the benefit of white men, and I am in favor of confining citizenship to white men, instead of conferring it on Negroes, Indians, and other inferior races. So that was a pretty clear statement by the most important political figure of the 1850s, that citizenship was for whites and these other, what he called inferior races, were not really part of the imagined community of the United States. This, of course, is what the Supreme Court said in the famous Dred Scott decision of 1857. During the 1830s, as many of you will remember this decision, or this case, Dred Scott, a slave in Missouri, was taken by his owner to Illinois, a state where state law prohibited slavery, and then to the Wisconsin Territory, where a law of Congress, the Missouri Compromise, prohibited slavery. Then, along the way, he married another slave, Harriet Scott, and they had two daughters. In 1846, he was back in Missouri with his owner, and Dred Scott and his wife sued for their freedom. Their argument was, by living in free territory, they had become free, and they should no longer be considered slaves. Well, this went all the way up to the Supreme Court, of course, and in 1857, the court ruled, no, Dred Scott must remain a slave. Why? Well, Chief Justice Tawney said, because no black person can be a citizen. Therefore, he can't even sue in court. This case doesn't exist because it requires citizens of different states to be suing each other to get a case to the Supreme Court. Dred Scott's not a citizen, so there's no case. Well, that's the end of the case. But Tawney decided to continue after saying that, and he went on to say that, in fact, the Constitution explicitly protects the right to property. And slave owners can bring them anywhere they want, basically, certainly in federal territory. And therefore, the Missouri Compromise, which had already been repealed, was unconstitutional. This was only the second time in American history that a law had been declared unconstitutional by the Supreme Court. The first one, of course, was in the famous case of Marbury versus Madison, more than half a century earlier. The most famous or infamous statement by Chief Justice Tawney in this Dred Scott case was where he talked about the founding fathers. People don't quite realize it, but the Dred Scott case is an exercise in what today legal thinkers call original intent jurisprudence. That is, the way to understand the Constitution is not by what it may mean today, but to go back to the original writers and what they meant by these words. Tawney said, look, we are actually more enlightened than the founders. We're not as racist as they were, but they believed that black people were beings of an inferior order, altogether unfit to associate with the white race, so far inferior that they had no rights which the white man was bound to respect. No rights at all for black people in the United States. That was the intention of the founders, according to Chief Justice Tawney. That statement, that famous, often repeated statement, said Thaddeus Stevens, the radical anti-slavery congressman from Pennsylvania. Stevens said that statement will damn Tawney to everlasting fame and, I fear, to everlasting fire. He's going to go to hell because of it. So, Tawney actually was a slave owner who freed his own slaves in the 1820s. He was not really pro-slavery, but he was interpreting the Constitution as he believed it ought to be interpreted. Dred Scott, however, was not the only definition of citizenship circulating at that time. In opposition to this racial definition of citizenship, the abolitionist movement developed what I've referred to as a purely civic idea of American nationality. The abolitionists insisted on the Americanness of slaves. They should not only be freed, but they should be incorporated as equal members of American society. They should have the same rights as other people, including citizenship. The abolitionists, not the founders, but the abolitionists were the pioneers of an idea of national citizenship, whose members enjoyed equality before the law. There should be no laws for white or black people. There should be laws that apply to everybody, protected by the federal government. And abolitionists, of course, denounced the Dred Scott decision. James McCune Smith, a not well-known but very important black author and abolitionist in New York, wrote a long essay on the decision in which he cited legal precedents, he said, going back to lofty Rome, to demonstrate that all free persons born in the United States must be citizens. Several northern states in New England denounced the Dred Scott decision and said they considered black people citizens of their states. Of course, there's hardly any black people in those states, but still. In 1858, the State Department refused to give a passport to Dr. John Rock. Rock was a black physician in Boston. He wanted to travel to Europe. The State Department refused to issue him a passport because they said, you're not a citizen of the United States. The legislature of Massachusetts condemned this and said it's an insult to the whole state of Massachusetts. But this was a minority view before the Civil War. It was as a result of the Civil War and Reconstruction that this abolitionist vision was transformed into the majority point of view and written into the laws and the Constitution. This represented a remarkable change in this imagined community of the United States. How did it happen? Well, the Civil War, among many other things, was a crisis of American nationhood and citizenship. Mobilization for war often produces an emphasis on national unity and an expansion of the rights of people in order to mobilize them for warfare. And the Civil War pushed to the forefront the question of who is really an American. Wendell Phillips, the great abolitionist, wrote, "It is a singular fact that unlike other nations, this nation yet has a question of what makes a citizen. We still don't know who is an American citizen," he said, in the midst of the Civil War. But the war produced the first formal definition of American citizenship. The most important thing that put this question on the national agenda, of course, was the end of slavery. Because the end of slavery immediately raised the issue, what is going to be the status of these 4 million people, now free, as American? Are they going to have the same rights as other people? Are they going to be a subordinate class? Nobody knew. In fact, even before the Emancipation Proclamation, in November 1862, the Attorney General, Edward Bates, the Attorney General, had issued an opinion stating that Dred Scott had been wrongly decided. I mean, it's interesting. The Attorney General said they made a mistake in Dred Scott, and we're not going to acknowledge, we're not going to abide by it. As far as we are concerned, he says, free black people born in the United States are American citizens. There's no reason to doubt their citizenship. Now, he went on to say that doesn't mean they have the right to vote or virtually any other rights. They're citizens, but it's the states that regulate what rights the citizens have. Nonetheless, this assertion of black citizenship galvanized black people north and south to demand other rights, particularly the right to vote. And Lincoln, although he didn't comment directly on Bates's policy, let it stand and in fact accepted the logic of it. In my book on Lincoln, one of the little stories I like very much has to do with a man called William Johnson. William Johnson was a black man in Illinois who Lincoln brought to Washington to work in the White House as a servant, basically, when Lincoln became president. So William Johnson is working in the White House, and then he died in 1864 of smallpox. And Lincoln arranged for William Johnson to be buried in Arlington Cemetery. Today, Arlington Cemetery is a military cemetery, but it wasn't then. Lincoln arranges for him to be buried, and Lincoln pays for this headstone that goes on the grave of William Johnson, and wrote the inscription. The inscription Lincoln wrote was just 3 words. 3 words. William Johnson, citizen. That's what Lincoln chose. This is Lincoln sticking it to Chief Justice Tawney, you know, right in the face of Chief Justice. But Lincoln accepts the idea this guy is a citizen. Now, of course, the opinion of the Attorney General can be overturned by the next Attorney General. I think more important in putting this question of black citizenship on the agenda was the service of 200,000 black men in the Union Army and Navy in the last 2 years of the Civil War. By the end of the war, it had become widely accepted in the North that by fighting and dying for the nation, black men had staked a claim to citizenship. They could no longer be excluded from membership in the American nation. And Lincoln himself, in his final speech before his assassination in April 1865, for the first time publicly said, I would favor, in the South after the war, I would favor giving the right to vote to some black men. Who? He said the very intelligent, that is, the free blacks who had gained education or something, and those who serve nobly in our ranks. In other words, the soldiers. The soldiers should have the right to vote, said Lincoln. at the end of his life. Well, of course, Lincoln did not live to put this into effect. Soon afterwards, he was assassinated. He was succeeded by Andrew Johnson, a strong contender for the title of worst president in American history. I still can't decide if Johnson or George W. Bush was the worst. But Johnson is certainly up there, or down there. Johnson lacked all of Lincoln's qualities of greatness. He was deeply racist, he was incompetent, he had no sense of Northern public opinion, he was inflexible, incapable of dealing with criticism. He thought black people should simply, they were free of course, but they should simply go back to work on the plantations and not bother white people with claims about citizenship rights or anything like that. And Johnson, of course, set up new governments in the South, completely controlled by white people, and those governments passed new laws, the so-called black codes, to regulate the status of the former slaves, and which basically gave them a few rights, such as the right to have their marriages legally recognized, which you couldn't do in slavery, but no civil rights, no political rights, and in fact, these black codes required adult black men to sign a labor contract with a white person at the beginning of each year and then labor throughout the whole year for that person. If you did not agree to work for a white person, even if you just want to work for yourself, you were deemed to be a vagrant and you could be arrested and fined and put to work for anybody who would pay your fine. Now these codes never really went into effect. They were soon abrogated by Congress, but their importance is that they turned Northern public opinion against Johnson's Reconstruction policy. They seemed to be a complete violation of the principle of free labor, which had been the groundwork, the base of the Republican Party. That's what was wrong with slavery. People had a right to compete in the labor market for advancement, to choose their employment, to leave their employment. The black codes were an attempt almost to restore slavery in another name. And the Republican Party, which controlled Congress, I'm abbreviating this history record, but very soon in 1866 embarked on its own Reconstruction plan, trying to push Johnson to the side. The first act that they enacted, the Civil Rights Act of 1866, is one of the most important laws of American history, and it begins by putting into effect this principle of birthright citizenship. First time in American history. This is where it comes from, in the law. Civil Rights Act. It begins by saying that anybody born in the United States, except Native Americans, because they are still considered citizens of their own tribal sovereignties, right? They're not really part of the American nation. They have their own nations. They're dealt with by treaty. Anybody born in the United States, except Native Americans, is a citizen of the United States. This is the first state, and that of course includes black people. It abrogates the Dred Scott decision. And it goes on to say, well, okay, here are what rights are they to enjoy? So it lists what rights all citizens are to enjoy equally, without regard to race. What are they? Owning property, making contracts, bringing lawsuits, enjoying full benefit of laws for the security of persons and property. Notice it does not mention the right to vote. That is not a right of citizens. That is organized by the states. Basically, it protects the rights of free labor, the right to get in the marketplace, acquire property, sue, be sued, sign contracts, etc. What's interesting about the language of this bill, very interesting, is that it uses the word equality, but it also says that all citizens were to enjoy these rights that I mentioned in the same manner as enjoyed by white people. In other words, this concept of whiteness, which before the war was a boundary of exclusion, whites had certain rights and other people didn't, now it's a kind of a standard. If whites have some rights, everyone else has to have the same rights. Whiteness becomes a breach of the barriers. The same manner as enjoyed by, that's an amazing thing actually, just a year after the end of the Civil War. A baseline, whiteness is now a baseline for the rights of others, not a privilege anymore, but a standard applicable to all. You know, the interesting thing is that this law, you know, we sometimes call the civil rights movement of the 1960s. A century later, the second Reconstruction. I think it was Suzanne Woodward who coined that phrase. Because it was the second time in American history that the federal government really devoted itself to trying to promote the rights of African Americans, 100 years later. And of course, one of the highlights of the second Reconstruction was the Civil Rights Act of 1964. But here's the interesting thing. In some ways, the Civil Rights Act of 1866 is a stronger law than the Civil Rights Act of 1964, 98 years later. The penalties against people who violate the rights of black people are stronger in the first law than the second. So it shows you it took us a century to get back to the principle of Reconstruction, and we never quite got there. Again, it shows you what an amazing moment Reconstruction was in American history. Well, of course, President Andrew Johnson vetoed the Civil Rights Act. It was passed over his veto by Congress, the first important law in American history to pass over the veto of the president. There had been some appropriation laws, but no significant law. But of course, a law can be repealed by the next Congress. So very quickly, Congress puts this principle into the Constitution in the 14th Amendment, the most important amendment added to the Constitution since the Bill of Rights. And an amendment which the current majority of the Supreme Court does not like. Does not like. Because whenever they talk about going back to the original intent, they go back to 1787. They never go back to Reconstruction to find out the intention of the 14th Amendment. The first clause of the 14th Amendment, as I say, puts into the Constitution this principle again. Any person born in the United States, then it says, and subject to the jurisdiction thereof, is a citizen. And moreover, they're all to enjoy the equal protection of the laws. Now, this business of subject to the jurisdiction thereof has become a point of political debate. In Arizona, they said, well, these illegal immigrants are not subject to the jurisdiction of the United States, and therefore their children aren't citizens. This is absurd. If they commit a crime, they're going to put in jail. They have to abide by the law. This is ridiculous. Who did they mean when they said people who are not subject to the jurisdiction of the United States? It's very clear. This is an obscure point. No politician today can answer this question. If you ever meet an American politician, ask him what the 14th Amendment means. None of them know. Including President Obama, by the way. There were three groups. One was Native Americans, I said. They're not subject to the jurisdiction because they have their own jurisdiction. They're still considered members of their own tribal nations. Secondly, and this is a small group, children of diplomats. If a diplomat has a child in the United States, that child is subject to diplomatic immunity and is not going to be a citizen. And thirdly, luckily, a class which we have not had to face this issue, but does happen, which is children fathered by occupying armies. This has been known to happen, right? Occupying armies sometimes produce children. Those are not to be considered citizens because their parents, their father is not subject to... All right. Anybody else, including the children of illegal immigrants, are citizens according to the 14th Amendment. The 14th Amendment also introduces into the Constitution this principle of equality among citizens. Something unknown before the Civil War. Totally unknown. There was not a state in the Union that gave black people full equality before the Civil War. The word equal is not in the original Constitution. The original Constitution says nothing about equality among citizens. That comes into the Constitution in the 14th Amendment. The 14th Amendment really creates a new Constitution. It's a Constitution which has become, in the 20th century, a vehicle to which groups can appeal who think they are being deprived of equality. Whether it's African Americans, women, lately homosexuals, immigrant groups, all sorts of groups can seize on the 14th Amendment and go to court to demand equal protection of the law. That was a fundamental change in the structure of citizenship in the United States. The 14th Amendment also is a fundamental change in the federal system, that is the relation of the states and the national government, because it empowers the federal government to protect the rights of citizens and to make sure the states do not treat citizens in an unequal manner. To see the importance of this, just compare the 14th Amendment with the Bill of Rights, the first 10 amendments added to the Constitution in 1791. The first words of the First Amendment, as you know, talks about freedom of speech, freedom of the press, freedom of religion. The first words of the First Amendment are, Congress shall make no law abridging the freedom of speech, etc. The Bill of Rights is a restriction on Congress, on the federal government, because at that time the general opinion was the danger to liberty was a too powerful national government. It had no bearing on the states at all. You could not give a speech against slavery in South Carolina. Was that a violation of the First Amendment? No. That's a state measure. Nothing to do with the federal government. Massachusetts had an established church, a church supported by taxpayer money until the 1820s. Was that a violation of the First Amendment? No. That's a state, not the federal government. Now, go to the 14th Amendment and the 13th and 15th, the three Reconstruction Amendments. All of them end with a clause saying, Congress shall have the power to enforce this amendment. So look at the change. Congress shall make no law. Congress shall have the power. This empowerment of the federal government to override the states. The whole center of gravity in the federal system has shifted to the federal government because of the Civil War, of course, and because, as Charles Sumner, the abolitionist senator, said, the federal government has become the custodian of freedom. It was the states that maintained slavery. The federal government abolished slavery. So if you want your rights, you've got to have a strong federal government. Now, the 14th Amendment said nothing about the right to vote. That will come soon afterwards. I'm almost out of time. I'm not going to give you the whole rest of the history of Reconstruction, except to say that with black suffrage, black male suffrage, women did not vote anywhere at this time, came this remarkable experiment of what we call radical Reconstruction, a period which lasted various times in various states, 1867, it ended finally in 1877, when the United States for the first time experienced interracial democracy. Or perhaps we just say democracy, forget about interracial. Just democracy, where, not for women, but where all men in the South, white or black, could vote and could hold office, etc. Before the Civil War, only a tiny number of black men in a few states could vote. And that's how two black men got elected to the Senate from Mississippi. That's how something like 2,000, by my count, more or less, 2,000 black men were elected in Reconstruction to some office in some state, ranging from local justice of the peace up to sheriff, member of the legislature, state official, one governor, some lieutenant governors, 16 members of Congress, 2 senators, etc. Most power remained in white hands, but the advent of black office holding and some local black political power was a remarkable change in the whole political system of the United States. Now, of course, it was a remarkable change, and it proved to be short-lived. Reconstruction, this experiment, was overturned by violence. It was overturned by Northern retreat. The North eventually gave up on enforcing the rights of black people in the South. And it was succeeded by a long period in which The 14th and 15th Amendments and the Civil Rights Act remained in the Constitution, but they were flagrantly violated in the South with the acquiescence of the rest of the nation. One part of this long retreat was the retreat from the notion of equality among citizens and a narrowing of the rights that came with being a citizen. As I say, it's one thing to say, okay, you're a citizen, but what comes with it? What does that mean? What do you have? What rights do you have because you are a citizen? Well, little by little, the Supreme Court narrowed down the rights of citizenship. They kept saying, yes, blacks are citizen, no question about it. Indeed, they said children of Asians born in the United States are citizens, a famous case in the 1880s. Asians from Asia cannot become citizens. But if they do come here and they have children, those children are citizens. That's what the 14th Amendment says. It doesn't just apply to blacks, it applies to anybody. So, all right, but what rights do they have as citizens? Well, first of all, it doesn't apply to women, they said. State laws limiting the rights of women do not violate the 14th Amendment. The famous case here was Bradwell versus Illinois. Illinois had a law prohibiting women from practicing law. Women could not become attorneys. Myra Bradwell, who wanted to become a lawyer, sued and said, this is a violation of the 14th Amendment. I'm a citizen. I'm supposed to have equal protection of the law. How can it be equal protection if it says men can become lawyers and women can't become lawyers? Supreme Court said, well, look, everybody knows women can't be lawyers. They just don't have the mental ability, rationality. It'll injure them in some way. So this is nature. This is not a legal problem. This is just nature has decreed that women cannot be lawyers. So it's not a violation of the 14th Amendment. Myra Bradwell said, well, when you read this opinion, you have to conclude that men can't be lawyers either, because it's so irrational. The Supreme Court quickly ruled that citizenship does not mean the right to vote. States can regulate the right to vote. So you don't automatically have the right to vote because you're a citizen. It depends what the laws of each individual state are. In 1883, when they overturned the last of the Civil Rights Acts, the Act of 1875, which tried to integrate public accommodations, you know, hotels, theaters, restaurants, public transportation, the Supreme Court said, no, that's all unconstitutional. It's not a violation of your rights of citizenship if a private business discriminates against you. What we're talking about here is public discrimination, is the government discriminating against you. So private business that is not a violation of your rights of citizenship. Interestingly, that issue has come back into our politics again today. Senator Rand Paul, the son of Ron Paul, the presidential candidate, Rand Paul, senator from Kentucky, recently said, in talking about the Civil Rights of 1964, which also banned this kind of discrimination, he said, I'm opposed to that. I don't think people should discriminate, but private business has a right to do whatever it wants. The government can't discriminate, but it's a violation of liberty to tell private businesses how to operate. So if a business wants to say, we're only serving white people, or no Jews are allowed in here, no Asians, that's all right. That's not a violation of the Constitution according to Senator Paul. But the Supreme Court had said that over 100 years ago in 1883. And finally, of course, Plessy v. Ferguson, 1896, which involved public discrimination, not private, public. A state law mandating that railroads set aside black people to one separate car in railroad trains. That's not the railroad's decision, that's a law of Louisiana saying all the black people have to be in one car. And the Supreme Court said, of course, no, that's not discrimination either. It's not a violation of your rights of citizenship, as long as the car is separate but equal, right? As long as it's a nice car. That was the principle. As long as it's a nice, comfortable car, no problem here. Because after all, they said, blacks can't go in the white cars, whites can't go in the black cars, so everyone's being treated equally here. So this is, again, blacks remain citizens, but the rights of citizenship increasingly were narrowed until we get well into the 20th century. But what's, I think, important, just to finish, is that even though violated, the 14th Amendment, the Civil Rights Act, the 15th Amendment remained on the books. They were not repealed. They remained what Charles Sumner called sleeping giants in the Constitution. And eventually, they would awaken. The Civil Rights Movement would awaken the sleeping giants, and they became the basis for the legal assault on segregation and inequality. It's interesting that the Civil Rights Movement did not produce a single constitutional amendment. We did not need a new constitution. Like, for example, when they abolished apartheid in South Africa, they had to write a whole new constitution. We did not need a new constitution. What we needed was to enforce the constitution we already had from Reconstruction, which had been egregiously violated. And eventually, after Reconstruction, it was to a great extent. So just to finish, you know, we Americans like to think sometimes that our history is a history of a straight line of greater and greater freedom. The United States began perfect and has been getting better ever since. But actually, as this story shows, it's a much more interesting history of ups and downs, of gains and losses. Rights can be achieved and rights can be taken away. Thomas Wentworth Higginson, the abolitionist who commanded one of the first black units in the Civil War, wrote at the time, "We are in a revolution, but revolutions may go backward." Reconstruction was a revolution that went backward, but the fact that it happened at all laid the foundation, almost a century later, for another generation of black and white people to try to bring to fruition the goals and aspirations and the concept of a country beyond the tyranny of race. And this controversial notion of birthright citizenship, the notion that anybody can become a good American citizen, regardless of where they came from, regardless of their origin, regardless of their race, ethnicity, is one legacy of that great struggle to create a nation founded in the principle of equality. And my view is it would be a terrible tragedy if, because of the politics of the moment, we alter or abandon that principle. So thank you very much for listening.